Good evening, everyone. Thank you for joining. Glad to have you participating in this seminar tonight, where we're going to talk about the new Fannie Mae loan requirements. We appreciate you joining. We know that all of you are well paid and you're going to make a lot of money joining tonight. So we appreciate you giving us your time. I think you'll find this to be a very useful topic. My name is Stephen Parker. I'll be the moderator tonight. And I am with the president of First Service Residential in Nevada. Our presenter tonight is John Leach. John has been in the HOA industry for over 35 years. I know he doesn't look like that, but he's been in the industry for a long time. So John's not only an expert in HOA law, but he's also a friend to the HOA industry. John participates in many industry presentations with CAI and other organizations to help better the industry. And so we appreciate not only his expertise in the legal field, but the fact that he's a great friend to the industry. Let me share with you our agenda tonight. I think you'll find the information interesting. As I mentioned, I'm from First Service Residential, and we are the property management, one of the largest property management companies in North America. And we're happy to partner with associations across North America to try and deliver exceptional service and solutions to them. John is with the firm Leach, Kern, Gruco, Anderson, and Song. That's a long name, but every good law firm has a long name. And so we're happy to have John here. As I mentioned, he's been practicing law. His firm has kind of since the beginning of HOAs. And so we're really excited to have him here. Now, let me share with you our agenda tonight. Hopefully you're aware of some of what's been happening with the new lender questionnaire. This came about because of the tower, the Surfside, Florida, the tower that collapsed. We want to discuss that sensitively tonight. We're aware that some of you may have had people involved. At First Service, we had an executive he and his wife were actually killed in that collapse. And so we want to share with you that information tonight to help paint a picture of how some of this came about, but also want to be sensitive to the fact that this is a fairly recent tragedy, and we certainly share the condolences with those who may have suffered a tragedy in this. Then we want to spend a few minutes talking about the Fannie Mae Form 1076 questionnaire. There are some new questions on this, which are causing lots of issues for homeowner associations. Spend a few minutes talking about the board's duty to respond or not respond. And John does an excellent job talking about that and helping you to understand that. And then we want to close up with some consequences should the association not respond. What happens if you don't do anything with this questionnaire, and what are some of the liabilities if you do something with this questionnaire? And then after we're done with that, we'll open it up to some questions and take a few minutes and field those questions. You have on your screen a questions box. If you want to type any questions in there, that would be great, and we will answer those towards the end. John, I'll turn it over to you.
Stephen, thank you very much, and thank you to you and to your team for putting this program together and sponsoring this. I think it's very relevant to all our associations, any of our condos and high-rises. This is very timely, so I appreciate you doing this. And I think I shared with you earlier that I have to confess that I'm a little bit surprised that this subject is not getting a little more traction with some of the community management people that we work with, because it is very important, and I would think that it would be, from just a liability standpoint, it's worth a discussion. And so I appreciate First Service Residential being out in front of this train, so to speak, and making sure that people are getting the information before there's a problem. I think the old ounce of prevention, or if you are prepared, you won't fear. So it's a good way to start your life. So, and lastly, before we get started, for those of you that might be attending from California or Arizona, please. We appreciate you doing this, and admittedly, I practice law in the state of Nevada. I'm not admitted in California, Arizona. I am acquainted with several of the attorneys in both jurisdictions. As a member of the College of Community Association Lawyers from CAI, I know what I consider to be some of the finest lawyers in America who practice in Arizona and in California. And while some of the statutes or codes we might reference tonight may not be identical in your jurisdiction, I'm quite confident, based on my conversation with others, that you will see that this is very relevant to you, and that the statutes and codes are very similar to those that are actually applicable in your jurisdictions. So I don't think it'll be a waste of your time. I think it'll be hopefully be worth your while. But again, when the sun sets, it's very important that whether you're in Nevada, California, Arizona, that you discuss these questions with your counsel. I'm not trying to usurp any of that. I want you to know that I don't believe I have a corner on the market, but it's just something I feel very passionately about. But I do want you to make sure that you consult with the people, the professionals that you have confidence in. So this program shouldn't change any of those things, Stephen. So
Thank you, John.
You bet. So I mean, just looking at this graphic alone is shocking. And if we woke up on the morning of June the 24th, and looked out our window and this is what we saw, I think we would all be shocked, heartbroken at what happened. So let's go to the next slide and just keep in mind some of the things that happened here, what the results were. So this tower was actually constructed in 1981. It was completed in 1981. And Surfside is it's a suburb of Miami. And the buildings, there are 3 buildings in this complex, all which were kind of L-shaped. In the building that we're talking about, there were 12 stories and 136 units in the tower, including a rooftop penthouse that I think went almost the full length of the building. But it was a large structure. It'd been in existence. Now let's do the math. 2021, so it was in existence for 40 years, and so that might be part of one of the issues that we have here is the age of the thing. So let's go to the next slide. As a consequence of this incident, and I thought maybe you'd find this interesting, I did, that this damage took 12 seconds. It's shocking to think about that, but the eruption, the collapse itself, took less than 30 seconds to take place. The pool deck of the South Tower had suffered what they call partial progressive collapse. And when it started to collapse, it was followed, if you can look at the picture below, the central section started to go first because of the location of the pool, and then the east wing of the tower followed right behind it. And in looking at it, as they examined it, roughly half of the 136 units were completely destroyed. But obviously the others were not, because it's not like you could save half a building. So next slide. And so in that morning, those early morning hours, here are some of the shocking consequences. There were 98 people who lost their life in this terrible collapse. 11 additional were injured. 35 people were actually rescued from the uncollapsed portion of the building. And then they were able to locate 4 people in the rubble, 3 of which survived, 1 did not. But ultimately, because of this absolutely horrendous experience or event, the entire building had to be destroyed. It was demolished about 10 days thereafter. So the whole building had to come down. As they started looking at the facts of the case, it began in 2018. And on the next slide, you'll see that what happened is an engineering inspection took place 3 years before the collapse. And that inspection identified a, quote, major error in the construction of the pool deck, and that the waterproofing had not been properly installed or properly sloped. And as a result of that, coupled with 40 years of existence, there started to be a problem. So the waterproofing below the deck was beyond its useful life, and it would need to be completely removed and replaced. As you can imagine, here you're taking a pool on the top of a building, or in this one area above the garage, and we're going to completely remove it when you've got to realize that it's connected together with all these other parts of the building. The engineer notified or contacted, maybe has warned the board and or its community management team of the concrete deterioration, and that if it wasn't repaired soon, that there are serious problems. And look, there isn't a board member alive that isn't concerned about the costs that are associated with the things that they're required to do. And this was going to be a very expensive item. So the board didn't take immediate action. There were hairline cracks and exposed reinforcing rebar from the spalling that was in the parking garage. So keep in mind, the parking garage, the ceiling of the parking garage was just below the pool. So the pool was above, then you got the parking garage. But they could see in the parking garage some of the hairline cracks and the rebar that were exposed because of the long-term deterioration of this area. Next slide. In 2022, so about 2 years later, the board actually tried to do some initial repairs to the pool area, but the contractors would not complete it because they felt that the deterioration was so bad, I guess beyond what they had expected and anticipated, that it had penetrated so deeply that they did not feel that they could go forward because of what they called it the risk of destabilization. If we go forward, we're concerned what this is going to mean as we try to remove these things. What's it going to do to the other components of this building when we do it? So the contractor shut down and they didn't go forward with that. On April the 9th, and after I'm certain some deliberation and some rough nights, the board sent out a letter to all the homeowners notifying them of a $15 million remediation program. And as I'm sure you can appreciate, folks, this isn't something that they had in their reserve study or reserve account. They're just sitting there waiting to be used. This was going to require a rather significant assessment on the homeowners. So they sent out the letter to the homeowners notifying of this. And then on June 24th, a mere 2.5 months later, they had actually started some of the roof repairs. They had started some of the work, and whether that destabilization contributed to this, we don't know. But the remodeling of the concrete had not yet begun at 1:22 a.m. on June 24th when the building collapsed. Let's go to the next slide. And so, you know, and sometimes we're better after the fact, but in hindsight, these are some of the factors that the professionals, the contractors, engineers attributed to this incident. Was since the 1990s, so for 30 years, there'd been a land subsidence in that area affecting this building. And then the insufficient reinforcing steel, so that the steel and the rebar was not sufficient. And then again, they felt that there might have been at the front end of this, back when they were actually doing the project itself, were there some shortcuts taken? You know, when an engineer says, yeah, there are major errors in this, when they're looking back at it, were there some shortcuts taken for whatever reasons that may have, in fact, if you read the articles, they'll talk about alleged corruption in the original construction. Well, one thing we've learned is that people don't wait very long to sue homeowners associations. And literally within less than 24 hours, a lawsuit had been filed that named the association as a defendant, seeking $5 million in damages. So one of the residents filed a complaint, and it was more in the context of a class action, because there were going to be other class members who arguably would be able to participate in this. But I thought it was interesting, and as we go through this tonight, you'll see why I feel this way. But the plaintiff in that lawsuit said that we're filing this suit due to the defendant's acts or omissions and their failure to protect the lives and the properties of the plaintiff and the other class members. So keep in mind, as we go through tonight, the protection of lives and the protection of properties, which in my estimation is really the guts or core of an association's responsibility. In response to the lawsuit, this wasn't something that any board member could have projected when they decided to run for the board, nor do they feel adequately prepared to be able to address it. So a receiver was appointed to represent the association in all of the jurisdictions that are represented here tonight, whether it be Arizona, California, or Nevada. There are statutes that govern the appointment of a receiver, and clearly in this case, the receiver, an independent receiver, was appointed to oversee some of the legal issues as well as the claims process. So a mere 5 months later, or 4 months in fact, Fannie Mae, in response to this horrendous experience, issued a letter to lenders. And if we can go to the next slide, I'm just going to point out a couple of parts of the letter. I didn't put the whole letter in here, but I thought I would point out the parts that I think are so relevant to us today in our industry, whether we're attorneys, community managers, or board members. So Fannie Mae issued a letter that says, in the wake of this tragic collapse, residential buildings with aging infrastructure and significant deferred maintenance are a growing concern across the nation. And then they go on to say this concern is expected to increase. Well, of course it is, because if part of the issue is the age of the infrastructure, then as the communities we live in, as they get older, whether condos or high rises, it's going to become relevant. In fact, you might live in a situation right now where the building's 10 years old, but 10 years from now, it's 20 years old. And so you might not feel like right now that this is as relevant for the development you're in right now. But Fannie Mae wasn't discriminatory. This applies to all the condos with some minor exceptions and high rises because of their growing concern of not only this, but can you imagine the loss of life, the liability, and things associated with this experience. They went on to say, and you will see on the next slide, that they went on to say that in response to the concerns about projects with significant deferred maintenance, we're issuing temporary requirements that impact the eligibility of condo and co-op projects containing attached units. And you'll notice that they said that this applies to all loans where the projects have 5 or more attached units. 5 or more attached units. That is pretty all-encompassing when it gets into how it's going to affect our condos and high rises. But I underlined the phrase significant deferred maintenance for a reason. And part of the reasons, as we go through again tonight, I want to make sure that we understand that deferred has a meaning: put off, postponed, delayed. And when we went through the Surfside fact pattern, we saw that there were some decisions to postpone and delay some of the construction or repairs. But this whole thing is focusing very much on deferred maintenance. And when we get to the Fannie Mae letter, you're going to see, I think that there's some assumptions being made in the questions which make it very difficult for you and I and our team, to respond to some of the questions because of the way the question is written. So it's just important to realize that they're really focusing on this. And the next slide shows really what this applies to: all loans purchased on or after January 1st, 2022. So today, as we sit on the last day of March, we're 3 months into this. And in fact, the letter itself was published in October. And so this has been in effect now for 90 days or more. And many of them are we're just learning about this now and how we're going to go forward. So next slide. We're now going to spend just a few minutes going through the Fannie Mae questionnaire itself. And as we do this, please understand that your management team has been answering questionnaires for you forever. Management companies have been answering these for you. Every time there's a resale, they get contacted and they answer questions like, here's copies of the governing documents. Do you have a reserve study? How much is in the reserve study? Here's a dollar amount. What's the assessment? Are there any delinquencies? Questions that were rather straightforward and could be answered with a yes or no or with a number. But you're going to see that this questionnaire doesn't lend itself to that. And please also note that the lenders in the industry do not necessarily have to adopt the exact same questions that Fannie Mae is asking. So when you get a lender's questionnaire, it may pick and choose the questions or actually rewrite them slightly as that lender sees fit. But generally, I believe that the comments we have tonight will be useful for you as you go through this exercise. So let's just go to the next question, or next slide, I apologize. And you'll see the first question they ask is, when was the last building inspection? As an attorney, we always tell our clients, listen to the call of the question. When? That's a time, that's a date. And guess what? You might not know that. Just imagine if the management company's only been working for the association for a year and this building's 20 years old. They may not know when the last building inspection was, and nor may any of the board members. And many times, at least in Nevada, we don't get building inspections that often. Now, if you were involved in a construction defect lawsuit at one time, there may have been some inspections at that time, and if you have them, we can disclose them. But that's a date, it's a time, and if you don't know, the right answer is I don't know, unknown, because you don't know the answer to that. And the worst thing you can do is guess and be wrong. The next question is a follow-up on the first question. Did the last inspection? If you couldn't answer the first question, then you can't answer the second question. And even if you did answer the first question because you knew when there was an inspection, you're going to see we don't answer questions about safety, soundness, structure integrity, or habitability, because I don't think anyone of us in this webinar tonight are qualified to do that. I know as an attorney, I'm not qualified to tell you whether a building is structurally sound or whether it's there's the integrity of it reaches a proper level. I don't know that. So the next slide kind of emphasizes that, because it again focuses on these buzzwords of safety, soundness, and structural integrity. Is your association aware of any deficiencies related to these things? And so again, if you'll look at the note at the bottom of the page, who's qualified to make that assessment? Not a community manager, not your attorney, not a board member. I suppose if I have a board member as an engineer, that board member might have the background that they could help, but we're not qualified to do that, because even if I knew that there was a problem, how do I know its impact on the safety, soundness, or integrity of the building? I would not know that. So this is the kind of a question that's going to be very difficult to answer, and we have to then, as you'll see later, come up with a method for how we're going to respond to these things. Next slide. Are there any outstanding violations of the jurisdictional requirements? In other words, if the city or county, the municipality that you live in has issued a letter to you saying, hey, this association has some outstanding violations, then we'd have to answer yes. This is maybe while you might be inclined to say this is a yes or no question. Once again, outstanding from where and when, how far back do you have to go? And was this management company really involved with the association that far back, which makes, again, very difficult. And then question number 5, is it anticipated that the project will have such violations? Well, I know I want to answer no, because we don't ever anticipate that, but we'll show how we're going to answer that in just a bit. Well, you're good. The next slide. So does the project have a funding plan for its deferred maintenance? And look at 7, does the project have a schedule for deferred maintenance? Please note, this question assumes there is deferred maintenance. And in fact, there may not be any deferred maintenance. So the premise of the question might be incorrect, which again makes it difficult to answer, because if you just answer yes, then you're acknowledging that there is deferred maintenance, and there may not be deferred maintenance. Just be cautious as you are considering those kinds of questions. Next slide. Has the association had a reserve study completed on the project within the past 3 years? Now, from the Nevada attendees, you all are familiar with the fact we don't need to get a reserve study every 3 years. The current law is every 5 years, which is not to say we won't see a change in that in our next legislative session. But right now, an association can be in compliance with the Nevada law by having a reserve study, an on-site reserve study, a full reserve study once every 5 years. Now, in Arizona and California, I do not know what that time period is, but your council does, and I'll bet my board members from those jurisdictions know too, because this is something that's probably ingrained in you quite a bit. But so look, just imagine this. If you say, no, we didn't get in the last 3 years, I think you probably want to explain, well, in the state of Nevada, we only need to get one every 5 years. Here's a copy of the reserve study, and you can see we are in compliance with Nevada law. We have a reserve study. The next number, what's the total of the current reserve balance? You know, that's a number. You can pull that off the financials. That doesn't require a legal opinion or anything of that nature. It's just a number pulled from your financials. And maybe you can tell them this is the amount as of the date that's on the financial. The next question on the next slide is, are there any current special assessments? And again, this is one that you probably don't need the lawyer to help you with. Do you have a reserve assessment or a special assessment? Yes or no? If the answer is no, then the rest of the questions are moot. You don't answer them. If the answer is yes, then you can go ahead and answer the amount, the terms, and the purpose of the reserve assessment. Is there some project that we needed to raise the money for? And we would explain that in this process. Please understand that just because you have a special reserve assessment does not mean there's deferred maintenance. It means there's a need to make repairs, but it doesn't mean it's necessarily deferred. So that's why, again, but you'll be able to answer that question if there is a special assessment. You'll know that. Your community management team will be able to help you with that. And the next slide, which is the last of our slides from the Fannie Mae form, is has the HOA obtained any loans? And once again, you'll know. And I can tell you that in the hundreds and hundreds of associations that we represent, there's less than a handful of associations that have ever obtained a loan to do this. But if you have a loan, you borrowed money, explain it. How much amount that was borrowed and what are the terms of the repayment? So now we kind of said, I'm sorry.
John, so as you're going through this, there's a lot of complicated questions here that are not simple to answer. I think it's important for our audience to know that this isn't a California, Arizona, Nevada issue. This is a nationwide issue. And if you've seen in any of the newspapers this topic being discussed, you'll see it's a big topic. What that ends up being resolved, how that ends up being resolved is still remains to be seen. But this topic about these questions is far from done. So I think we're going to see a lot more on that.
And Stephen, what a great point. Thank you for bringing that up. And keep in mind, it is a national problem, in fact, a national issue. And in fact, CAI, the national organization, has submitted requests to Fannie Mae and Freddie Mac asking them if they would consider deferring or postponing some of these requirements to give the industry time to get their arms around this, because all of a sudden the questionnaires popped up and here we are, we don't really have any opportunity to address some of those situations. So yes, this is, no matter where you're at in the country, this applies to you. So that's a great observation. The next couple of slides, again, they're going to be focused on Nevada. So please forgive me, my California and Arizona attendees. But like I said at the beginning, I'm very confident you'll see that there's some very similar standards. The first slide it's what we have in Nevada is our statutory fiduciary duty standard, and I'm very confident that all jurisdictions require board members or declare them to be fiduciaries. In Nevada, they say in the performance of your duties as an officer or director, you're going to act on an informed basis. Evans, you're doing that tonight, in good faith, and in the honest belief that your actions are in the best interest of the association. All of your decisions are to be for that purpose. Am I benefiting the corporation? Not necessarily a single homeowner, even the homeowner who's trying to sell their property right now. It's not, your fiduciary duty isn't to that person. Your fiduciary duty is to the corporation as a whole. Now, you're going to see that can affect the individuals, but right now we need to focus on our duty is to the entire corporation. And I've kind of always told my clients, and then when I've got opportunities to speak at CAI, if you look at the next slide, I think you can break this down to two things. You have a duty to protect, maintain, and enhance the value of the properties in the community and to preserve the health, safety, and welfare of the residents in the community. So what's interesting about this is you'll see that one has to do with property and one has to do with health, safety, welfare of the residents. Isn't it interesting that when the lawsuit was filed, the very day of this collapse, what did they say the defendants did wrong? Failure to protect lives and properties. And we've always kind of believed that our decisions should be made in such a manner as to protect, maintain, and enhance value. So when we make those repairs, we're enhancing value. When we take care of our communities, we enhance value. And we're preserving the health, safety, and welfare of our residents as we do these things. So it is interesting to note that even though the fiduciary duty standard doesn't necessarily say that, it's my belief that almost everything we do, and look at your agendas, folks, almost everything is people and property. And it's so important we do what we can to protect them. The next slide, this is in Nevada, what we're required to do on a resale. And there's a resale package, and management gets contacted. They're supposed to give them copies of the governing documents. Well, that's pretty straightforward. Letter B, a statement setting forth the amount of the monthly assessment for expenses, any unpaid obligation, and other expenses that are related to that. So what's the past due amount? What is the charge? Again, pretty straightforward. If you go to the next slide, we'll see that you're also supposed to provide them with a copy of the current operating budget. Well, the board's done their budget. They do them each year, and we're required in the resale package to give them that. Letter D, a statement of any unsatisfied judgments or pending legal actions. And in Nevada, we have to do that at least every 100 days in our meetings and our resale packages. We're supposed to make a disclosure to our homeowners that they know if there's any judgments against the association or pending legal actions. E, a statement about the fees associated with the resale. What am I going to get charged as part of the resale? What am I going to be assessed because of the resale? And then the last one is a statement describing all current and expected fees or charges for that unit. So that would be your assessments, late fees, interest, is there a transfer fee? You'll be telling about your fine policy. What are the expenses that could be incurred if there are fines or penalties or things of that nature? So my point is, none of these things in Nevada, and I'm going to guess in other jurisdictions, none of these things ask the board or management to opine on the structural soundness or integrity of a building. They ask you to give facts and data, not opinions. So Fannie Mae's request and now the lender's requests go beyond the scope of what the Nevada law says we are required to give. So that begs the question, should I even answer it? I mean, the statute doesn't say I have to do all this. So the next slide asks that very important question. What are the consequences? So if you don't answer this, if you choose to say, well, wait a minute, I'm not required to, and oh, by the way, I'm not qualified to, and I don't want to create liability for the association. I don't want the board or the association to be sued by giving misinformation. I don't want to interfere with this buyer and the seller who are trying to do this transaction. So we're just going to stay out of it. We're not a party anyway. It's the buyer and the seller. They've got their own contract. I'm just going to stay away. I'm not going to get involved. Well, here are just some of the consequences that I foresee could happen if that's our choice. First, the lender might say, I'm sorry, but if we can't get this information, then we're going to choose not to close a loan. We're not going to be able to do this loan. Obviously, it's going to have two unhappy people, a buyer and a seller that both have their heart set on this transaction. For us, the frustration will be the seller. The seller is a homeowner. The homeowner is going to think that, there's something wrong with us or be upset at us as homeowners, or excuse me, as boards and associations for not helping them complete this transaction. Third or second, it's possible that the association might be placed on lists where Fannie and Freddie say, you know what, we're not going to insure or approve any loans. And Stephen, my recollection is that the last data that I had, and I probably need an update here, but that 70% of the residential loans in the United States are tied to Fannie and Freddie, either through original, through resale on the market, or insurance. They're involved in 70%. So can you imagine if we are no longer eligible for their involvement? It's going to force our buyers to be cash buyers in many instances, and that makes it harder for your seller to find someone who can purchase the property. And I suppose if the seller was completely frustrated and believes that our failure to act was a breach of fiduciary duty, I guess they could say, I'm going to file a lawsuit against the association for failing to do its duty to help answer these questions so that I could sell my home.
Yeah, and I think that's what makes this complicated, right? Is you've got liability in how you answer these, and the easiest way to get rid of all the liability is just not to answer them. The problem is that doesn't make for very happy homeowners, and you're right. The majority of the home loans in at least the United States are backed by Freddie or Fannie, and whether they end up there or not, the guidelines used by Freddie and Fannie are used to qualify the vast majority of the loans in the United States.
So the rest of our program, before we get to your questions, the rest of the program is really going to focus on two things. Number one, I'd like to talk to you about a recommended approach. It's fun. It's nice to have this webinar and tell you about all this catastrophe and whatnot, but how can we approach this thing, balancing all the things Stephen just talked about, feeling this obligation to our homeowners, wanting to fulfill our fiduciary duty, not wanting to create liability? How do we handle this? And then the last part, after we finish that, I'm going to show you some language that might be useful in trying to respond to some of the questions that Fannie, Freddie, and the lenders are asking. So the first recommendation, and let's just go to the next slide, is give facts, not opinion. That should be the heart of what we do. We shouldn't have to opine as to things that are beyond our expertise, but we can give facts. We can tell them we have a reserve study. We can tell them the status of the reserve study. We can tell them how much money we have in the reserve study. Because when they're talking about deferred maintenance, they're generally talking about the major components of the common areas. So the reserve becomes very important. And if it's adequately funded, properly funded, are we following the schedule? Very important. But we give facts, not opinions. Second, consult with the professionals who are working with your association. I know that all my board members, you guys have attorneys and accountants and management. Management's the most important, but you've got an attorney, you've got probably have a reserve specialist. Consult with them. Talk to them on this issue, especially our reserve specialists who prepare these reserve studies and do the on-site inspections. The next slide gives you the statute, it's actually a code provision, excuse me, a code provision in Nevada. In Nevada, we have the Nevada Real Estate Division and the Commission for Common Interest Communities and Condominium Hotels, which they kind of oversee, if you will, the industry, and they scrutinize the conduct of board members and other professionals who work with the boards. And in determining whether you fulfill your fiduciary duty, one of the questions they asked is, did you consult with appropriate professionals as necessary before making any major decision affecting the association? And choosing just not to answer these types of letters, I think, is making a major decision. So before you do that, before you decide how you're going to answer, please consult with the professionals. There is safety in doing so. There's errors on omissions policy professionals. I have malpractice insurance. And if we make mistakes, then we can make our clients whole. You have directors and officers insurance. You're a human being. You're going to make mistakes. You shouldn't be penalized by making an oops, I made a mistake. But by acting this way, following this, you insulate yourselves from any kind of liability or limit liability because you're doing exactly what you're supposed to do when you make a decision. You're acting in good faith and on an informed basis, that information coming from your professionals. Next slide. So third, I recommend that you would meet with the reserve specialist annually to review the reserve study and to plan for maintenance repair of the major components. The reserve specialist has put together a plan for you. And over the next 3 to 5 years, you're going to be looking at that very closely to see how you're doing. Admittedly, the reserve study usually goes for 30 years, but the point is you're going to look at it in shorter increments. But meet with the reserve specialist at least annually. I mean, literally have them come see you, or I guess you can do Zoom or some other way, but meet with them regularly to plan for the maintenance and repair. Do they believe that there's a reason to postpone maintenance of an item for a year or two? Let the professional talk to you about that, and then make any adjustments to the reserve study that are necessary, both to your funding and to the schedule of repair. Fifth, comply with the schedule or be prepared to explain why you haven't. Because keep in mind, if you're sticking with the schedule, there's no deferred maintenance, is there? You've got a professional saying, I've looked at the site, here's the common element, major components, here's the schedule to keep them in good order. And if you are following that, then there's not a deferred maintenance because you're current with it. So the project questionnaires focus on deferred maintenance, and there may not be any. If there is, if you are following that schedule, and we'll show you maybe how to respond to that in just a minute. And the last two recommendations are to confer with the association's legal counsel in preparing a response, at least the first one. Again, this is not an attempt to have you pay your lawyers oodles of money. Your lawyers know very well that dollars spent on them are dollars you don't have in your operating and reserve accounts, and we know that. So But the first time you respond in your association, that it'd be wise to have the lawyer at least review that to look at how you're responding or assist you in the preparation. I'm grateful. I know that many of our clients, Stephen, the FSR manager has given us an opportunity to at least look at and prepare a proposed response, and so that they can see how we would approach the issue, which is not to say they're going to need us for the fourth or fifth letter, but maybe at the beginning it would be useful. And the last one is, if you have had a construction defect case, be prepared to add additional information to the response if possible. And you'll see what I mean in just a second. So that's our recommended approach. Our recommended approach is to give a response without answering all the questions. Does that make sense, folks? I'm not trying to make a joke out of it. I'm just trying to say, though, we are going to respond. We are recommending a response. We're asking just to be careful in how we respond. And that means we're not going to give a direct answer to many of their questions. We're going to give them facts for them to make their own decision, not our opinions for them to rely upon. So let's go to the next slide. I want to share with you just 3 more slides, and then you don't have to listen to me so much, on how we can respond to some of these questions. And normally what we'll do is at the beginning of the letter, we take the portions of the questionnaire that ask about deferred maintenance and jurisdictional violation notices and things like that. We don't pluck out of the questionnaire the questions that are, do you have a special reserve assessment? Well, that's yes or no. Have you borrowed money? That's yes or no. How much money is in the reserve account? You can give them that. We take the questions from the questionnaire that we don't believe lend themselves to a direct answer, and we put them in the response. Dear lender, you've given us this questionnaire, and included in the questionnaire are the following questions. And we lift from the questionnaire the questions that we think are problematic. We then educate them about, because again, deferred maintenance and reserves, we talk to them about what the reserve study is, what it means, and then after telling what the law is in Nevada, and we're going to do it in Arizona and California, your attorneys can help you with that, we then say something like the following. On this date, the association obtained a reserve study from, here they are. And here's a copy of the reserve study. We're giving it to you. It identifies the major components of the common areas. And then we say, if this is true, and again, and every time I do a letter, I highlight this underlined part, because I want to make sure it's correct and honest. The association is informed and believes it is in compliance with the maintenance repair schedule set forth in the reserve study. If we're not, if we have deferred maintenance, maybe the pool deck, maybe some asphalt slurry seal, because there's a project going on right now, and we don't want a slurry seal till the project's done because the damage could happen to the streets. That's okay. They're not. I don't think they're going to deny a loan because you tell them, oh, by the way, the deferred maintenance we have is this, and we're planning on doing it this way and whatever. So we either answer with, we're on schedule, which by the way means there's no deferred maintenance, or we have some items that have not, except for the following, we've complied, and then we list the 1 or 2 things or a few items that have been deferred. And again, hopefully you've already had that discussion with your reserve specialist so that he's already told you that, hey, you're not in trouble, or this is an appropriate thing to do. The next slide focuses on the fact that if there was a construction defect case that you're familiar that in your association, a paragraph something like this that gives them the date of the construction defect case, the case name, the case number, the department number. So now you're giving them all the information they need to have to do their own review of the docket sheet and review of the documents. If we have some of them, we can give them to them, but we don't have to do the research for them. We can give them the information. Now, in a couple of the cases I've been working on, there was, at the end of the construction defect case, the law firm that handled the CD case actually issued a summary sheet. And on that summary sheet, as you can see, we insert the date that the settlement was reached and what was recovered, and the date the lawsuit was dismissed. It's right in this letter. So we give a copy of the letter to the lender and say, here's the information. The lawsuit was settled on this date. Here's the case was dismissed. And if there is a letter that includes the scope of repairs, then we include a copy of that letter in that. We're not opining as to what that means. We're not saying it affects structural integrity or soundness or whatever. We're giving them the information, we're giving them the facts, and let them make their own decision. And the last thing we tell them is this: look, we're not aware of any violation from the state. So if you go to the next slide, you'll see we tell them, hey, the undersigned has not received any written report from the engineer or any written notice. Now you'll note there that it says within the past 12 months. Now the reason we did that is because in this case, the management company had only been there for 12 months. We don't know what happened before then, or at least we don't have anything in the file that suggests that. But we don't know what happened with any certainty before we took over, and we don't have to guess. So the undersigned has not received any written report from an engineer about this. And then we, as nicely as possible, tell the lender that it's our position or our belief that the lender now, based upon the information we've given, needs to make its own assessment as to the questions that are in their questionnaire, because we've given them the data, the information that's relevant, and we allow them, they have their own legal departments, folks, let them make their own decisions as to whether they want to go forward with the loan. We've responded, we've done the best we can with the facts and information without giving an opinion on things that are beyond the scope of our experience or knowledge. So that's kind of the approach, Stephen, that we are recommending. But please understand, I don't mean to bore everyone, but if your attorney has a different idea, please listen to him. I'm not here to sell you on this. It's how I'm recommending, but you have qualified folks that are working with you. Please consult with them and listen to what they had to say and work together to prepare a response to the questionnaires that are coming your way. And if they haven't come, they will, I promise. So it's just a matter.
That's very helpful, John. We appreciate your information that you shared tonight. I think it's an eye opener. Hopefully it doesn't scare board members off. I think fiduciary duty sometimes carries with it a bit of a scare. It shouldn't. We just need to listen to the people who are advising us and make sure that they're qualified. I will, before we tackle a couple questions, just do a couple things, and we're gonna get you out here on the hour, so we'll be on time. I want to just give you a little information about how this is kind of shaking out. At First Service Residential, we started working on this back in October. And so in January, we were ready and prepared with our clients to begin answering these questions appropriately. And as John mentioned, we don't recommend or say you need to go every single time, but you do need to get a template who we feels best answered from your legal counsel, and then you can use that template. I did want to give you just a summary. We have one association that in the last 3 months, we've produced about 10 lender questionnaires. And they've all been answered very similar to what John talked about tonight, with the appropriate answers on the appropriate questions. And about 4 of those have been declined because they didn't like that we didn't say yes or we didn't say no. The rest of them, we've worked with the whether it's a realtor or a loan officer to get them what they need. In some cases, we're providing 6 months or a year worth of meeting minutes, and they can look at it and say, okay, we see there's no discussion. So there is an opportunity to work with the lenders to try and get this moved forward and still answer the questions in a way that don't create liability for you. We are taking, however, about, I went down and asked today, about 10 questions a day related to this topic in our transfer and disclosure documents department that would answer all these questions about lender questionnaires. So it's definitely happening. If this is the first time you're hearing about it, I'd reach out quickly and have a conversation to make sure that those questions are being answered in an appropriate way. But just be aware, it is creating some backlog with this because we want to make sure that the questions are answered appropriately, and sometimes that creates some back and forth. But it definitely is something that you want to make sure is answered properly. So now let me just address some of these questions. I'll take some of them and I'll send some that are hard to John. So one of the questions that was asked is, do you expect these Fannie Mae questions will be adopted by other major lenders? Is this a canary in the coal mine, indicating all major lenders for condos and co-ops will be submitting to associations before approving? So I'm not sure it's the canary in the coal mine, it's the entire flock in the coal mine. And part of that is because Fannie Mae backs a large percent of the loans. And so really, even if you intended as a lender to hold the paper, you're probably having it approved per the Fannie Mae guidelines in case 10 years down the road you decide to sell that paper, and it would need to meet those guidelines. And so yes, I think this is going to become the major questionnaire. I do think there's going to be some work on it because, as I said, there's a lot of pushback, and 4 out of 10 loans declined is not a good number. So I think there's going to be some pushback on Fannie Mae, and the industry is doing a nice job of pushing that back. John, one of the questions that was asked, and you touched it just a little bit, what if we're already in the middle of a rehab project or a special assessment?
Again, let's do the second part first. Having a special reserve assessment is not a bad thing. If anything, it shows that you're proactively addressing the problem. Please keep in mind that in Surfside, the collapse, at least in part, was because things weren't being done. I think if they see that you have got that, that's why the question says, do you have a reserve assessment? How much? What are the terms? How long? And what's its purpose? And so I think, to me, Stephen, I believe that if a lender sees that they are proactively doing these things, they're going to be inclined to do it. Now, maybe a person who's buying says, "Oh my goodness, do I want to walk into a special assessment with a reserve?" That might be something that factors in. But from a lender standpoint, I think it's a good thing. And then if you are in the middle of a project, again, that doesn't mean that you necessarily have inspection reports and things like that. You might, but that might make it easier to answer some of the questions. But the sense I get, Stephen, is they're more concerned about people that have deferred maintenance and don't have a plan than they do that you have a plan and you're implementing that plan. I think, to me, that shows that's more important. I think that from their perspective so far.
Yeah, we don't get a sense in the loans that are being declined that there's a desire to decline the loan. There's a desire to buy a loan where the building is sound, or it can satisfy them that they're buying good paper. The loan is going to be good, and so I think that's an important piece. They're not trying to decline these, but it is a difficult process, and there's a lot of emotion around it because you're now dealing with a seller who's trying to sell their house. And if you're in a market where it's really hot, they want to sell it, and you're with a buyer who wants to buy it, and now you've got the association that's saying we're not going to approve this, and it looks like they're holding things up. You've got your manager who's getting yelled at, and so it's just a really difficult process. One of the other questions was, how is the lender questionnaire and the question they ask in a part of the sales process? So every loan that you receive as part of a loan for a mortgage is underwritten. And all of those have underwriting guidelines, and they vary depending on the type of loan that you're getting. But most of them, as I said, are backed by Fannie and Freddie. And that questionnaire is a required document for them to approve underwriting on that loan. And so that question has to be answered in a satisfactory manner in order for that loan to proceed through the underwriting department. It's a great question. Another question is, and I'll let you answer this, John, what happens to the sale if we just refuse to answer the question?
Well, I think that's what we went back before. Stephen, I think it's interesting that in that one association, 40% declined even though you did respond. I've always believed that trying to do the best you can, doing something is better than nothing. So to me, trying to answer the questions in a manner that we're protecting or limiting potential liability, but trying to accommodate our homeowners is the safer approach. Now, safer meaning what? Well, meaning that the homeowner is not going to sue us, meaning we're not going to get blackballed from them. We're doing our best, but it's a tough call. But I think, like I said, because I believe the board's fiduciary duty, each director's fiduciary duty is to do those things. They act in good faith and an informed basis, best interest of the association. Do property values, are they going to be impacted if we can't get Freddie and Fannie in? And if we're just choosing not to do that, it won't be long until the word is we only take cash buyers here, and that could affect the value. So I think we're better off trying, Stephen, and I'm not saying it's a perfect answer, but I think it's the best approach.
Yeah, and I think your last sentence there is really the rub. It's easy to say, we're just not going to answer these questions, and that's one end of the spectrum. The other end is that you just answer them yes, no, and you move forward. On the end where you're just not going to answer them, you are going to have an impact on your property values if all you're going to be is a cash association.
Yeah.
If you answer them yes or no, you may be creating some liability. And so we move to the middle and start to answer those questions in the way that John suggested, that removes the liability, but also makes it possible for the lender to look at that and say, hey, they're trying to answer these questions.
And Stephen, might I add, again, like you said earlier, you were talking after your comments were, give them 6 months of minutes, give them more minutes if you want, give them the financials for the past year, because you're going to give them the budget for the last year so they can see it. Let them see what the balance is in the reserve study. Give them a copy of the reserve study. We're not trying to hide it. We're trying to be transparent. It's just that we're telling them that we don't want to assume your responsibility to determine whether this is a credit-worthy project. We're going to give you all the facts that we have. We're not trying to hide anything from you. We're telling you about the CD case if there is one. We're giving you the names of the cases. We're telling you if we've got the summary sheet from it. But we're going to let you decide if that information is such that you don't want to go forward, kind of like the 4 folks in that one association.
Right. Well, let us leave you tonight with a couple of references, depending on which market you're in. On the next slide, we're going to show you some references where you can reach out and get some more articles or best practices around the conversation that we've had tonight. We really appreciate you, John, sharing your insights on this. This is an important topic. It affects, as I mentioned, property values. It ties into the liability of the association. And it's just a great topic to really kind of get informed about and to make sure that the answers you're giving to this questionnaire don't rule out any loans, but also limit the liability that you're creating for the association. Thank you to those who participate. We realize as board members, you have a lot of things to do. And we at First Service, we always appreciate your willingness to become more educated. So thank you for joining. Really appreciate this. Have a good night.
Thank you, everyone.